Welcome to Versus Trump, the podcast where we talk about how the Trump administration is breaking the law and what people are doing about it. I am Jason Harrow, one of your hosts, and I'm here in a two-person podcast with co-host Isha Anand. Hey, Isha, how are you?
I'm good, Jason. This is like the only two-person combo we haven't done yet. We've done a me, Charlie. We've done a you, Charlie. So it was time for Charlie to bow out for a week, so it could just be the two of us.
Exactly. So he will be back shortly. But for now, Isha, you and I are going to get into some simultaneously super wonky inside baseball stuff, but that also presents some really big, interesting issues that I'm excited to talk with you about. So before we divulge what that topic is, dear listeners, you know that you can find us online at takecareblog.com/podcast. You can tweet at us or read some of our pretty sparse tweets at Versus Trump Pod. You can email us, which we do get emails, versustrumppodcast@gmail.com, and we read them, and we try and read some of the feedback on the air as well. And you can rate us in your podcast player of choice. Okay, so that's the intro. Isha, the topic for today is some very controversial work requirements for Medicaid recipients in the great state of Kentucky, and maybe more states to come, and a big lawsuit over those requirements. So I do want to set up, I'll try and interrupt so this is not a super long monologue, and I promise the listeners that even though we're going to go into the mechanics of how Medicaid works, it's actually really interesting and important, and it's not as complicated as it may at first seem, especially in the hands of Isha Anand, who's really good at explaining this wonky administrative law stuff. Yeah, Jason, so with that,
Medicaid.
That's right. Explain Medicaid. You have 90 seconds.
Based on like one subclause out of tens of thousands in this Medicaid statute. So, okay, but listeners, we both were just talking before we got on the air about how fascinating we found this suit. And we rarely recommend you actually go read legal filings because a lot of the time, I mean, that's our job, right? Like our value add is you don't have to read the legal filing, we'll do it for you. But we both agree that this complaint actually does a really nice job of kind of breaking down how Medicaid works and how it fits together. So I don't know, Jason, what do you think? I would actually commend our listeners not only to listen to this podcast, stick around, it's going to get really interesting, but also maybe even read the complaint in this case.
It's good. Disclosure, it's a 79-page complaint with lots of citations to Medicaid law. That said, it's double-spaced, right? And there's a bunch of pages of like just statements about what the plaintiffs do, so that goes kind of quickly. But yeah, okay. I guess I would say if the listeners really want to dig deeply, this is as good a place to start as any this particular complaint because it is well done.
Okay, all right. I'm so sorry about that. So the subject of this, the subject of this lawsuit, which is filed by the Southern Poverty Law Center, the National Health Law Project, and some private law firms, is work requirements that have been superimposed on Medicaid. So right now there are 10 states that are trying to basically say, you can get Medicaid only if you work in some way or are looking for a job in some way. And the contours of it differ, but we're focusing today on the state of Kentucky. So just to step back, because I actually don't think I really understood what Medicaid was. I sort of knew it was this government healthcare program, but it's this sort of highly reticulated statute that says basically states can get federal funds if they commit to providing healthcare that meets a certain quality using processes that are sort of adequately simple for certain specific groups. So the groups are children, pregnant women, folks who are aged, blind, or disabled, former foster care youth, and this was the sort of big innovation of the Affordable Care Act, Obamacare, as of 2013, folks whose income is less than 133% of the poverty line. So that's about $34,000 for a family of four right now. And crucially, the way the statute is laid out, if you choose, if when you're providing this healthcare, you have to cover the whole group. You can't just kind of pick out a subset to do it. And the statute has a bunch of other kind of strictures in order for you to get your Medicaid funds. And so every state has chosen to participate in this program to get federal government money in exchange for providing healthcare to these certain groups. So I should say all states have chosen to provide healthcare for the children, the blind, the aged disabled, the former foster care youth. A number of states have chosen not to provide what's called Medicaid expansion, which is Medicaid coverage to this new group, the 133% of federal poverty line group. That's the sort of controversial. Some states have taken the Obamacare Medicaid expansion. Some states have decided not to take it.
Yeah, and just to add a little bit to that, Isha, sorry to interrupt early. When, Isha, you're talking about states taking it. That's because it's not a actual federal requirement, it's a deal, and the deal is that the federal government will reimburse the states for a large to overwhelmingly large portion of the cost of the program. Depending on the exact population, I believe it's between 80% and basically 95% reimbursement, right, Isha? So it's between silly and completely nonsensical for states not to join the whole thing, but because of politics, as you said, some states did not accept the full Medicaid expansion, even though the deal is a very, very favorable one for the states that do.
Right. And we should note that originally Obamacare said, states, you got to accept Medicaid expansion. So you got to cover these folks who don't fit into one of the other buckets, but are below 133% of federal poverty line. And then the Supreme Court stepped in and said, and Obamacare said, and if you don't, we're yanking all your Medicaid funds. And the Supreme Court actually stepped in and said, you can't do that. Like, you can say they won't get extra funding, you can incentivize them to cover this new population, but you can't require it. Incidentally, because it's going to be relevant when we talk about the politics of this whole process later on, Kentucky is one of the states that has actually accepted Medicaid expansion. Of the 10 states that have these new work requirements, 5 have accepted, 5 have not accepted. So in Kentucky, if you make up to 133% of the federal poverty line, you get Medicaid coverage. Okay, so what's this lawsuit about? So essentially, Medicaid is this whole scheme. It's got tons of requirements for who you have to cover and how you have to cover them. But there's this kind of a funny little provision. It's 1115 is what we're going to call it, 1115. And it basically allows a waiver of parts of the statute if you're doing something sort of experimental. So basically so Congress wrote the whole statute, and then they said, executive branch, you're going to administer Medicaid funds. And we've got all these really this sort of maze of requirements, but for experimental pilot projects that you think are likely to promote the objectives of this act, you can kind of waive some of these requirements. And so under this kind of waiver provision, Kentucky has sort of come up and said, here's our proposal. We have an idea for a pilot project. And it departs from the Medicaid Act in a whole slew of ways. The most dramatic one is that we're going to impose basically work requirements. We're going to say you've got to spend 80 hours a month doing something. And, there's sort of like various, there's a good cause exception. This doesn't apply to all the groups. There, job search activities can count and so on. And there's a bunch of other kind of provisions we'll get into as we kind of go down in a little more detail into this lawsuit. But basically it says, here's our pilot project. And, they did this in 2016. They got, the Center for Medicaid and Medicare Services got thousands and thousands of comments objecting to this. But then on January 11, 2018, the Centers for Medicare and Medicaid, which is run by a woman named Seema Verma, who will become important later on, sends this letter to all state Medicaid directors basically saying, here's our kind of like new theory of how this waiver provision works. We actually really want to encourage these experimental proposals. Specifically, we want to encourage experimental proposals that have work requirements for various reasons. And the next day, on January 12th, they stamp Kentucky's proposal yes. So Kentucky can implement this pilot project that does not look a lot like traditional Medicaid, not just because of the work requirements, but for some other reasons, with the kind of imprimatur of the federal government saying, we're not going to yank your funding. We think that this is a good pilot project for you to check out. So the Southern Poverty Law Center promptly files suit. And the kind of crux of their suit is basically a bunch of the pieces of this pilot project both, one, violate the Administrative Procedures Act. So the Administrative Procedures Act says federal agencies, you cannot do anything that is arbitrary or capricious. And this lawsuit basically says, look, if you look at all these tweaks you're making to Medicaid in this pilot project, it sure looks pretty arbitrary. I mean, these things are really contrary to the spirit of Medicaid. You haven't thought about all these kind of important factors. You've weighed things improperly. You're making essentially a wrong decision. And then two, this exceeds your authority under 1115. So 1115 says you can do a limited experimental pilot project, not totally transform the way Medicaid works, right? You're allowed to do these kind of small scale experiments to sort of test out different theories for within the strictures of Medicaid, make things, sort of more efficient. This is a wholesale revision on a statewide basis that has nothing to do with the spirit of Medicaid. So those are kind of the two big picture claims. And that's kind of the structure of the lawsuit. And we'll get into a little bit more the details of Kentucky's program and the kind of details of how this waiver came to pass. But initial gut check. Jason, are you persuaded by this?
I have to say it's a very well done complaint by the Southern Poverty Law Center. This is one of the suits that I have encountered. There is a big but. This is one of the suits that I have encountered so far on this show. And as listeners know, we try to call them as we see them. But as we went through the Trump administration scorecard, it had a lot of losses in 2017 in the cases that went to court already, or they withdrew, or they changed positions, because as many people know, the Trump administration did not do the greatest job of taking care that the laws were faithfully executed. They often did things that were impermissible or outside their authority. And sometimes when they did things that could have been permissible, they justified them on grounds that were impermissible, and courts recognized that. And so I think we recognize that and talked a lot about those cases. This is not one of those cases, Isha. I am as well done as the Southern Poverty Law Center's complaint is. I am reasonably persuaded. Again, this is early. All we have is the first filing in this lawsuit. We don't even have a motion to dismiss yet. In fact, all the government has asked for right now is that this case be transferred from the court where it was filed, which is the District of Columbia, to a court in Kentucky. We're not going to talk a lot about that, whether it gets heard in Kentucky or in D.C., as you know, Isha. These issues will get aired. But we don't really have the arguments on both sides yet. So, early times. But in those early times, I do think that, one, the Trump administration is acting on pretty solid ground because it has pretty broad authority. And for that point, and I can get into all the 3 points that I want to make here in some depth, but just to preview that one, right? This section 1115 that you mentioned, Isha, that's really the key to the suit, says that the federal government, can allow states to put in all these new requirements as long as it's part of an experimental, pilot, or demonstration project that is, quote, likely to assist in promoting the objectives of the Medicaid program. That's extremely broad. And as our favorite health policy and law commentator Nick Bagley wrote in a recent editorial, only on rare occasions will the courts invalidate a waiver. Okay, so one is they're starting with lots of power. There just is lots of power here. Two is they're doing this not on an ad hoc basis, they being the federal government, but after a reasonably well thought out, candidly reasonably persuasive 10-page memo that does not hit some of the impermissible things that Kentucky and other states who wish to implement these work requirements may be considering, right? So I do think it's right, and the Southern Poverty Law Center and press around this says you're not allowed to just put new requirements on Medicaid recipients just because you want to save money and you want to kick people off the rolls, right? The federal government has given you a deal, cover these people or don't cover them. You can't pick and choose. You can't pick the ones that you want, that you think are working hard for it and not. If you meet the requirements, you get health insurance. That's the way it works. And there are other programs to incentivize people to work and get job training and things like that. Medicaid is not the place for that. So that may be what is motivating Kentucky, Isha. But the federal government, in its considered opinion on this, doesn't say that. It really takes very seriously the argument that other federal programs over the last decades have gone in the direction of trying to get people working who can work, right? This does not apply to to disabled people, to pregnant people, to the elderly, but people who can work but with low income. Federal programs have, over recent decades, tried to get these people to go to job training and not indefinitely be on welfare. And whether or not that's realistic, whether or not that's good, that is the reality. And the Trump administration discusses that and takes it seriously, and I think considers it seriously. And the third thing, and to me, the real tiebreaker here, that in some ways, the unfortunate dagger in the heart of this complaint, of the plaintiff's entire legal case here, is just what the Obama administration did over the last several years in the arena of healthcare, in just acting so unilaterally and contending that it had such incredibly broad authority under the Affordable Care Act, precisely because Congress refused to meddle in the arena of healthcare, and it was so hard to get action. And so the Obama administration justified drastic departures from statutory text in order to make a healthcare program work in the way that it wished. I just don't see how people can then in good faith come and argue and say the Trump administration can't do the same thing. So that's my summary of my three problems with the lawsuit. And anything persuasive?
I disagree so much. Man, I don't even know where to start. Let's work backwards. Let's take your last point first, okay? So Well, actually, can I do an overall preface here before I get into running?
And I just want to say before you preface. Sometimes, as you know, I try to take the Trump administration in its best light or play devil's advocate. I'm just going on the memo here. This is like good for Seema Varma. Honestly, yeah.
This is your honest opinion. Okay. Yeah, we really appreciate the devil's advocacy. This is one of the first times you said I'm not just playing devil's advocate. I'm actually persuaded here. So here's the kind of backdrop preface before I get into the individual arguments you've raised, which are compelling in their own way. The backdrop here is we have set the bar so freaking low for the Trump administration, right? They've got a 10-page memo that doesn't say anything overtly racist in it, right? 10 pages for essentially totally revamping healthcare. Doesn't say anything overtly racist. Has some citations, right?
It does in footnotes. Yeah.
It's got footnotes. They didn't, to their credit, they didn't just fully rubber stamp the Kentucky proposal. They made some modifications. For example, they said you've got to exempt anyone who's an acute medical condition. You've got to say that substance abuse counseling can replace some of those 80 hours of work. You have to make sure complying with the Americans with Disabilities Act. You have to kind of ensure that there is work for these people to do. You can't just say, go out and find a job with their new jobs to be found. So they also did this kind of seemingly reasonable thing where they didn't just rubber stamp Kentucky. They actually made some modifications and put into place some requirements. But let's not forget that lots of things have been struck down with memos that are a whole lot longer than 10 pages, that don't say anything overtly racist, that don't just look like rubber stamps, right? Administrative procedure is not just designed to weed out instances where someone has a one-paragraph blatantly racist justification. It's also designed to weed out instances where, there may be a lot of kind of well-considered research, but it nonetheless doesn't pass the sniff test. It nonetheless isn't in accordance with the structure of the statute. It nonetheless doesn't consider things it's supposed to consider or inappropriately weights things. It nonetheless cites studies that sort of can't be, that actually are not valid to cite. I mean, we give a lot of deference to agencies, but it's not just formal deference, right? It's not just literally if you put something in with footnotes, I guess that's going to pass muster. Usually we have a document to critically read, and we still decide sometimes that the agency has acted in a way that can't be upheld. And that we forget that in the Trump administration, because most of the time we don't have a considered document to read. So we started to think of agency law as just striking down anytime an agency does something with zero justification. So that's
okay, great point. Can I give you a brief response? The Trump administration cited and the Trump administration acknowledged that the prior administration had taken a different view. And it cited to the Center for Medicaid Services rejection of New Hampshire's 2016 proposal for work requirements. I am now going to read to you, Isha, the entirety of the Obama administration's reasoning for rejecting New Hampshire's proposal for work requirements. Quote, after reviewing New Hampshire's amendment request to determine whether it meets these standards, CMS is unable to approve the request, which could undermine access, efficiency, and quality of care provided to Medicaid beneficiaries. Period. That's it. That was the reasoning.
So let me defend that, and then let me go through your 3 points, okay? So here's my defense of that. This is a waiver provision, right? The default is you follow the statute. Congress wrote this thousands of pages long scheme that they thought would best ensure that folks who are disadvantaged in some way got access to healthcare. And they put in this little tiny waiver provision that says, if you meet all these stringent requirements, then maybe you don't have to follow the statute. And so the burden of proof is on the state, right? The presumption is you follow the statute. And so, there should be a high threshold for being able to opt out of the statute. And you don't meet that, you kind of follow the statute as written. So it strikes me that you have to do a lot more explaining if you want to give someone a waiver than if you don't want to give someone a waiver, right? Because if you don't want to give someone a waiver, you just follow the law. That's the general state of things.
It's a good point.
Okay?
I'll let you move on. We don't have to go back and forth on
that. Okay, let's get into Jason's 3 arguments. So Jason's 3 arguments are essentially Obama administration used and stretched this provision, 1115 gives broad authority, and really well-considered letter, roughly speaking, right? Okay, so on the first point, the Obama administration abused this provision. I think it's crucial to kind of follow along with the text of the statute here, right? So it's got to be experimental project, and it's got to be likely to assist in promoting the objectives of the Social Security Act. And to me, that's kind of the crucial piece here. The experimental projects can't be, as you said, about savings. It has to be about improving health outcomes. And so, like there is an effort being made to say unemployment is related to health because there are all these studies that show that the people who are unemployed, are in poorer health. The studies, as Nick Bagley points out, not particularly well done because they tend to confuse causation and correlation, right? Like people who are not particularly healthy tend to be unemployed. So it's not clear that like unemployment is what's causing poorer health. But it strikes me that there's a very big difference and a very different amount of leeway given to a program that's designed to expand coverage, where it's like really obvious the connection between expanding that coverage and someone's health being better, right? Like when you're covered, you're more likely to go see a doctor. We know from a million studies that were touted during the Obamacare debate that having health insurance leads to better health outcomes in a causal and not just correlated manner. And there it seems like, you can use this waiver provision in a lot of ways that are coverage expanding. But when your coverage contracting, again, you've got this much higher burden because the waiver is only supposed to be for projects that, again, promote the objectives of this act. And so, it's not intuitive that contracting coverage in any way promotes those objectives. And so, I don't know, I think you got like a kind of slightly higher burden there, don't you think?
One kind of minor point and one major point. The major point is that I was using the Obama administration's actions more broadly than just what the Medicaid waiver provision was used. I'm saying that the way that they mucked around with the Affordable Care Act, right? In 2013, they literally just decided that the date that Congress said to implement the employer mandate was not when they were going to decide to implement it. And they justified it, as I understand it, on the basis that sometimes the Department of the Treasury delays taxes in order to give parties more time to comply. I mean, the law was passed in 2010 and they were supposed to be implemented in 2014 and then they waived it for another 2 years. Basically just because people were mad and they didn't think that the authority was just, we're going to make this work and it's really hard to get Congress to legislate it all on healthcare. They're not going to change it. And therefore, we have to use our authority to muck around in this area. And they mucked. I mean, are you disputing the general mucking around with healthcare that the Obama administration did or no?
Well, I am. So again, I'm pushing back on the analogy. So I was talking about the specific way that Obama used 1115. But again, I think there is a big difference between taking actions to try to make the statute work, try to achieve the statute's objective as written, and actions that, at least on their face, seem to go against the kind of spirit of the statute. Okay, and I think that those are so fundamentally different that they just require categorically different levels of scrutiny.
I think that is taking this administration, which admittedly does not often come with a presumption of good faith, but I think that's taking it in too much of an overly bad faith way, right? I read this memo with an open mind, and I understand I read the same source, and we'll link to the article that Nick Bagley put up about how uncertain this evidence is. But I don't think it's crazy to think that in good faith, a typical administration is allowed to write sentences like saying that a Gallup poll found that unemployed Americans are more than twice as likely as those with full-time jobs to say they currently have or are being treated for depression. I don't think, if this were a normal Republican administration or a centrist administration, I think you could think, Isha, there are people of good faith who actually think that, creating an incentive for people to get into the workplace more broadly, which encompasses volunteering, which encompasses job training, which really does make people feel better about themselves and have better health outcomes. There are a lot of people that think that in good faith, and I don't think it's fair to say that there's no way that anyone can in good faith think that doesn't promote the causes of Medicaid, especially when it's in some other more recent federal welfare programs, right? And so I think that they won the election because of the Electoral College. They get to make those determinations, and they have some leeway. And unless you're reading it in really bad faith, that you're saying they just want to kick people off the rolls. I mean, do you deny that some people can think that this really will help make people healthy?
Yeah,
you deny that.
Okay, so we're gonna link to. I see at least 3 problems with this line of thinking.
Okay.
The first is it's not clear who they're talking about. The second is that it's not clear that they've thought through the negative externalities of what they're doing. And the third is how this specifically affects folks with disabilities, right? So we'll post a link to some studies in the Journal of the American Medical Association and from the Kaiser Family Foundation that basically looked at what are folks on Medicaid doing. And so they find that 80% of adults in Medicaid are from working families or are working themselves. Of the rest, there's a third who are unable to work because of some kind of illness. Another third are taking care of members of their family in lieu of jobs. Another 20% are students. Another 8% have looked for work but can't find it. Another 8% are retired. That leaves 3% of the non-working population, which again is only 20% of the population, who could possibly be in this category of like could work but aren't, right? So we're targeting this incredibly, incredibly small sliver of the population. So that's point one. Point two is, in targeting this incredibly tiny sliver of the population, there's a ton of negative externalities that are not being fully accounted for. So, we said we'd get into a little more of what Kentucky's program looks like later, and now is maybe the time to do that. So
now is later.
So now is later. So the way this new Kentucky program works, first of all, everyone, they're exempting pregnant women, children, and foster youth from some of these. So when I say everyone, I'm generally exempting some combination of those groups. So just take that caveat. But you get a $1,000 deductible for all non-preventive services, from which like money gets drawn every time you take advantage of one of the services, supposedly to help you understand what your healthcare is costing. You accrue money in a kind of My Rewards program for, quote, healthy behaviors. So they kind of monitor whether you're doing work-related activities, and they kind of give you like bonus points for that. This work requirement is not just that you have to work 80 hours a month. You have to document that and submit the documentation. And if you don't do it right and you don't show good cause, you're suspended. You are suspended from the program. You don't get health insurance. You have to pay a premium that depends on kind of your income and your time enrolled, but can be up to $40 a month for folks who are in this program. And if you don't pay it and you don't pay it on time, you're locked out for 6 months. If you go to the ER inappropriately, you pay a $20 penalty. This lockout period stuff where you're banned from being on Medicaid for 6 months, even if you get into compliance, that applies for administrative noncompliance, meaning if you don't fill out your paperwork correctly. Think about the folks who are on Medicaid, right? These are folks who are incredibly poor, which is usually linked to having all sorts of disabilities and having a low education level. What we're essentially doing is we're saying, there's not just a work requirement. We are saying that here are like another several hundred pages of regulations. And if you don't follow them correctly, not only does your Medicaid get yanked, even if you fix it, you still have to wait 6 months to get it back. I mean, this is a huge negative externality to target the 3% of the 20% of people. It's some tiny number that I can't, figure out right now, who are able-bodied but not working. I mean, it's an incredibly punitive measure. And so I think that, if you seriously believe that unemployment caused depression, as opposed to unemployment being correlated with depression, namely that folks who may not have a defined disability still can't work for reasons outside their control, fine. But gosh, you're looking at a really small number of people you're helping, and you're looking at a lot of people who are almost certainly going to get kicked off the rolls for various administrative failures, even if they could theoretically qualify under some sort of good cause exception.
Yeah, I actually don't disagree with anything you said, Isha. I really don't. I mean, I think that it's probably silly policy, like you said, because most people who can work, do wish to work, and recognize the health benefits and recognize the societal benefits and the family benefits. And there's many, many other reasons to work, right? And they do. The administrative burden that the state is trying to implement here, which is all new. I think even the state, in news reports I read, kind of recognizes this is going to be tough. How are we going to track it? What are we going to do? All of that I agree with. I do. But I don't think it changes the fact that the fundamental core of this program, which is, can you add a requirement that non-pregnant, non-disabled, non-elderly people who are on Medicaid, certain subpopulations of Medicaid, work or participate in community activities 20 hours a week in order to receive benefits under the law? Is that a valid grounds for granting a waiver? Because it is experimental. Surely it's never happened before. I think in good faith they want to study the effects of it. And I do think, according proper deference to the administration, I do think it can in some broad way assist the purposes of and assist the goals of the Medicaid program. Boom. I think that's all they got to do, right? There's only been 2 instances where waivers have been struck down by courts as invalid. I don't see this stepping beyond those, stepping in being a third. I really don't. Again, don't dispute that it's probably bad and futile and silly and onerous policy. All of that's true. Question is, can they do it?
Okay, so I've got a minor and a major rebuttal. The minor rebuttals, I just want to clarify for folks, because I do think this is an insidious part of this. When we say non-disabled, theoretically, this Kentucky program says folks who are disabled don't have to do this 80-hour-a-week work requirement. What they're talking about is folks who qualify under the disabled kind of category. So if you come in because you get SSI benefits, which are benefits if you prove you have a disability, which is a fairly high threshold. I don't know if you had this experience when you were clerking, Jason, but we saw there's this kind of really kind of complicated 5-step process to prove you're sufficiently disabled to get Social Security disability benefits. So if you come in through that pathway, then you're exempted. But if you're disabled, but you don't meet this incredibly high threshold to get disability benefits, but you're poor and you come into this program, you're not exempted. So I just want to make that's sort of a minor point I want to make clear. Here's the major point. If you're not convinced by the fact that it seems kind of like it makes me roll my eyes to think that someone in good faith could think that coming up with this incredibly onerous system that was almost certainly going to deny coverage to a whole slew of people who should qualify in order to target this really tiny number of people who are unemployed. If you don't think that that shows evidence of bad faith, consider this. There have been public statements by all kinds of members of the Trump administration, including Seema Verma, the administrator for the Center for Medicare and Medicaid Services, who published in a Washington Post op-ed saying, this is your chance to fundamentally transform Medicaid, that suggests that what's going on here is not just an experimental or a pilot project that is limited in scope and duration so as necessary to test a hypothesis, which is the sort of language of the statute, but it's got to be limited, it's got to be a pilot project, it's got to be experimental. Trump administration officials, including the woman in charge of the agency that wrote this memo letter, have admitted that they want to fundamentally transform Medicaid. They've admitted that they have this is not sort of some sort of limited pilot project. And, to be clear, like the legislative history, and for our non-lawyers, that's the kind of commentary surrounding the passage of a statute that's not kind of part of the statute. And some courts and judges would say you ignore that stuff altogether. Some courts and judges say, like, if you're trying to figure out the meaning of a provision in statute, you should look at what everyone said around the time it was passed, even if that's not sort of part of the law. So there's some legislative history in the Senate report that sort of says, experimental, like statewide programs wouldn't qualify, right? And so the notion that they're using this waiver to implement some kind of test or pilot project where they're really open-minded about how this hypothesis turns out, and they're just trying to gather data, and this is a way to conduct a kind of controlled experiment to figure out, to inform themselves, is belied by the fact that everyone in the Trump administration who's talked about this has said, we want to fundamentally transform Medicaid.
Yeah, and that is a fascinating point, but I think my response is, welcome to the new normal. Welcome to the new normal, because in 2 senses. One is, this is in line with the direction that executive authority and executive rulemaking and things have gone. The Obama administration fundamentally transformed a lot of environmental law and a lot of healthcare law and a lot of education law. I mean, we don't talk too much because none of us are really experts on education, but the kind of waivers and pilot programs and charter schools and things like that Secretary Duncan and the Obama administration were doing was wild for people in that industry, because Congress, we're in a period where they don't act very frequently. Their overall action is down. Their willingness to make technical fixes and small bipartisan changes is substantially down. And so we're in this phase where there's just lots of executive lawmaking because of point 2, which is the new normal fits with these broad waivers. Congress has done this frequently. They say, here's the program. It's super complicated. We spend lots of time talking about it, except you can waive out, right? Except we want the executive to have some authority to change it. And that's in there, right? I mean, like it or not, that's in the statute, and it's broad, and courts have read it broadly.
I mean, I hear what you're saying, that it's in the statute, but it's not that. I disagree that it's broad, right? Like, it says it's got at least 3 requirements. It's got to be experimental, demonstration, or pilot, right? So it can't just be transform Medicaid. It's got to be some sort of bounded project. It's got to be likely to assist in promoting the objectives of the Social Security Act, which we've already talked about. And it's got to be only for the extent and period she finds necessary, as in to prove or disprove the particular hypothesis you're trying to show, right? It's not a waiver that says, in your best judgment, sometimes, like, for example, immigration statutes contain a bunch of waivers that basically say, if you, in your judgment, believe that it's best for someone to remain in this country, like, go forth, right? There's no bounding criteria. This waiver actually reads really narrowly to me.
So that is interesting. It does seem to be narrowed in terms of time. I don't think there's a good faith argument that the permanent revolution of Medicaid can be accomplished purely through a waiver of this type, because experimental, pilot, or demonstration does seem to mean we can't have all 50 states doing this indefinitely. If those 3 words mean anything, it means that they're of limited duration in time. Limited in scope, right? You're right. You quoted the history from the 1960s of senators going, this will be just not statewide. It's been applied to statewide programs very frequently. This is not new for the Trump administration, and that makes sense. You can run a statewide demonstration, pilot, or experiment. You can. You can run a nationwide experiment, pilot, or demonstration. But no, I think you can. The time, it does seem like it has to end. And so I do think that if the goal here is to fundamentally change Medicaid, I do think a better way of interpreting what they're saying is we're going to let lots of states do this. We're going to see if they're successful. And then eventually we'll have to go to Congress and get a tweak if this is going to become permanent. And we'll have the evidence to do it or not. And in reality, it'll probably be up to the politics. And that's why, Ayesha, and we can go back and forth on this. I do hear ya. I really look forward to this case getting litigated. I don't want to cut you off or anything, but I do want to introduce one other component of it, which is backlash. Okay, you know that I'm a big believer in thinking about the backlash of everything on here, maybe just because of the legal education I had in my constitutional law class with Professor Michael Klarman, who's a huge advocate of backlash. But put aside a little bit the legal reasoning here, which you've obviously done expertly. If implementing these programs can sustain Medicaid for a longer time, because without them, as we've seen from the welfare reform acts of the 1990s, there is major backlash among a huge segment of the population. Does that change your opinion of whether or not the administration should approve them, of whether liberals should be okay with having them be approved?
So, and we should note that this is more than just a hypothetical question. In one kind of famous Second Circuit case that we'll link to that upheld a kind of change to the welfare program that imposed a work requirement, Second Circuit, part of their logic was, well, this actually advances the objection of the statute because there's growing antagonism to welfare. Yeah. And so it might get cut unless you do something about it. And so really in the long run, this is going to save welfare. So there you go, right? I think that what you're describing is an empirical claim, right? And we have some evidence, right? So there was TANF, Temporary Aid for Needy Families. We imposed some work requirements on them. The new requirements did not lead to significant changes in employment, did not lead to significant reductions in poverty. They cost a lot to implement, and they have not saved TANF from being sort of the object, the sort of political football, right? I don't think that it's the case that as an empirical matter, we're not political scientists, so we can't evaluate the empirical evidence, but in any kind of sustained way, but at least kind of anecdotally, it doesn't seem like this does much to save these programs. There's so much misperception about these programs, right? The fact that folks who decry Medicaid because they think folks on it are unemployed probably don't know the Kaiser Family Foundation statistic, which is that 80% are from working families, and of the remaining, only 3% are folks who are able-bodied and choosing not to work, right? And so I see no reason to believe that changing the work requirements will change the public perception somehow, that will make people understand any more what Medicaid's about. And if your goal is really to change the kind of public perception, why wouldn't you start with an education campaign about how few people there are on Medicaid who kind of fit this stereotype in the first place? I just don't think this is a claim that seems to have no foundation, and therefore, one of the few things that the Administrative Procedures Act abhors and allows courts to strike down is decisions made without empirical foundation.
Right. I do think that's a really good point, right? It is possible that, especially in a state like Kentucky, the expense and administration of trying to implement this program, which, as you said, is going to apply to a much smaller number of people than many non-Medicaid recipients think, right? I think lots of people, like you said, have this outdated perception, perhaps media driven, perhaps not, of just loafers, right? And whether those are class-based discrimination or whether it's just images in the media, whether it's race-based, whatever, it's just these loafers that get all these benefits. And, you know, the old 90s term was welfare queen that I guess the Republicans, you know, coined in the 1990s to describe that. And as you say, the empirics just don't say that, right? It's working people, disabled people, people trying to get ahead who can't, people who have lost things, people who have had medical emergencies and went bankrupt and now need some. I mean, the articles about this program, and, you know, we haven't talked much about the specific people involved or how good a job this litigation has done of bringing their stories, but one that really resonated with me was a couple people, one of whom is a seasonal worker, right? And owns a lawn cutting business, but that's dormant in the winter. And another who's just trying to start a business on their own and just literally says, I don't want to be on Medicaid, right? But if I'm going to take a risk and start my business, I need some health insurance. I don't have a lot of income now. My goal is to get off Medicaid, right? And so totally agree that the population of people using this program is very different, and the economics of it and the health outcomes are very good from a cost-benefit perspective. But I do think that the question that I am trying to answer, to go back to it, is can a state try and run an experiment like this? And if no, I hear you that there's ways to say that this doesn't fit within this waiver requirement. It's hard to pin down what does and what doesn't, because the waiver requirement is, in my view, relatively broad. I think maybe that's the fundamental disagreement that we have is how broad can this waiver requirement be read. I read experiments to be lots of experimentation and assist in furthering the goals of Medicaid to be very broad and subject to the discretion of the executive branch. Fair.
You know, so let me just leave you with kind of one final point. So we've talked about the kind of what I perceive as a kind of the bad faith on the part of the Trump administration, even dressed up in this 10-page memo, namely that they're relying on sort of outdated empirics. They're not accounting for the cost and the loss of coverage. And they've sort of said publicly that their goal is not really to experiment, but to transform. We haven't talked a lot about the Kentucky side of the equation. And there, I think there's even more cause for concern, right? So Kentucky's not a defendant in this lawsuit. The question is whether the federal government did the right thing by saying, Kentucky, you can go ahead with this and still receive federal funding. But, you know, there's an article in Kentucky newspaper that notes that Governor Bevin of Kentucky has made a statement that he will end Medicaid expansion, so end that coverage for folks who don't fit into one of the buckets but still are making less than 133% of the federal poverty level, altogether if a court finds any part of this waiver invalid, right? So he's trying to blackmail healthcare advocates into not filing suit. And I think that when you kind of like look at the actual text of this Kentucky requirement, it's not just that they impose a work requirement, like we said, it's that they do all these other things that just seem vindictive, right? So the monetary penalty for inappropriate emergency room usage, right? Like, no one chooses to go to the emergency room if they don't think they have an emergency. It's not a pleasant place, right? Yeah. Like no one's like, you know what I really want? I want to sit for 4 hours around other desperately ill people while I wait to get some kind of care. People go to the emergency room because they think they're having an emergency. And if you're someone who's severely ill or disabled and you're subject to a lot of pain, it may be difficult to tell what is actually a medical emergency from what is kind of a chronic feature of your disability or illness. So provisions like that, you know, often doctors can't tell, right? I once had a kidney stone, and the first doctor I saw thought that I just had stomach cramps and sort of sent me home. And I finally had to go to the ER after I was kind of vomiting from pain. And another doctor was like, oh, actually, yeah, you probably should have come in sooner. You don't have a kidney stone. It's going to like rupture something inside of you. This is really terrible.
Ouch.
But even doctors can't necessarily tell, right? Like the first doctor I saw thought this was, it would have been inappropriate for me to go to the emergency room. You know, so anyway, that's all to say that whatever argument you can construct in favor of the Trump administration, I would be really hard pressed to defend Kentucky's good faith in passing these regulations, which again seems to me like the Trump administration surely should have seen that. And even if they're okay with work requirements kind of in the abstract, should have seen what Bevin has said in the media and the way that this program is structured and said, this is not like the kind of experiment we want to sign on for.
Yeah, that's fair. Does the fact that this is a cooperative federal state program mean anything to you? Because in theory, right, the beauty of Medicaid is that if you would like to receive the Medicaid benefits and you don't want to comply with the work requirements, you can move. Nothing is forcing you to stay in Kentucky and accept these onerous conditions. Does that have any resonance to you?
So I think that is an incredibly slippery slope. That's not how we generally think of laws as working, right? We never say, you know what, if Kentucky shuts down all the abortion facilities in the state, you can move, right? Like New York still got an abortion facility. So like but
that has to do with constitutional rights and the availability of constitutional rights.
And Medicaid benefits, that's a statutory entitlement, right? The due process clause attaches. There's a bunch of case law saying you can't take someone's Medicaid benefits without providing them with some kind of process because we understand that this is essentially your property.
Well, sort of, right? But as Governor Bevin said, the state doesn't actually have to accept it, right? This same population of people could be living in a state that didn't expand Medicaid at all, and where they could just have no access to Medicaid at all.
Right. So totally understood. I think there's a pragmatic problem and a philosophical problem. Pragmatic problem, we're talking about the most vulnerable people. We are talking about people who do not have the money to, who don't have a car that they can get into and drive across state lines, who don't have money for an Amtrak ticket, right? I mean, we're talking about we're talking about folks who are disabled, who are pregnant, who are underage, who are overage, people for whom it would be incredibly difficult as a pragmatic matter to be like, you know what, see you, Kentucky, I'm going to find another state to move to, right? So that's point one. And then the kind of philosophical point is this. The reason that the Medicaid statute has this provision, and it's 1396 A10B, all right? So it's buried in the statute, but it's there, that says you've got to cover the whole group. You can't just cover a subset, even among the kind of optional groups you're covering, is because we don't want states to draw arbitrary lines. That's part of kind of the Medicaid experiment, is you're not going to kind of rely on the generosity of a case-by-case approach. You're going to say these are vulnerable groups, and we're not going to draw kind of lines that will frankly tend to fall along all kinds of discriminatory axes, whether it's along the kind of disability axis, whether it's along a race axis, and so on. We're instead going to say you take it all or don't take it at all. And if Kentucky wants to turn down a whole bunch of federal money, then so be it. That seems like a silly policy decision, but so be it. But what Medicaid doesn't tolerate is this kind of arbitrary line drawing kind of within a subset of the group.
Yeah. Okay. No, that's interesting. And I will say, as often I do, I totally appreciate the thoughtful comments. I am somewhat moved. I'm going to continue to think about it. Like I said, I think this is one of the closer cases. I think the Trump administration did a decent job, and I think they have some authority here. But I'm persuaded to take another look and to really think about the limits of the waivers, notwithstanding what I take to be your somewhat, in my view, extraordinary defense of some illegal and unusual actions by the Obama administration. I think those are still hanging out there. And I think I still haven't heard a good explanation for those. But just because even on my view,
regular listeners will know that Jason is the consistent one among us, right? Like believes in standing every time or no time.
No, but this is also not even about consistency. Even if the Obama administration illegally waived a timeline for the Affordable Care Act, this is a different provision, right? I mean, I do take that. I do take that point. I'm just talking about more optics here and the general field. Okay, so that was a lot of fun. Let's go to and. To close it up, listeners, as we said, the case has been filed in the District of Columbia. The federal government has asked for it to be moved to Kentucky, so no briefing yet on the merits of this. As we said, 9 other states have applied for this. Indiana has just a few days ago, been approved. Other states no doubt will be approved, and there will no doubt be more litigation over those states as well. So this is an issue that's going to just keep getting bigger and bigger and more prominent, and whatever venue this gets argued in, right? The District of Columbia, Eastern Kentucky, somewhere in Indiana, will get an answer, presumably, because I don't think either side is going to back down on this one, Isha, do you?
No, not at all.
Yeah. Okay. So to quick Trump nuggets, I want to Trump nug moving across the South, somewhat south and west from Kentucky to Texas. A great article by Lauren McGaughey, who is the state capitol reporter at the Dallas Morning News, that I'll link to, entitled, "With Trump in Charge, Why is Texas Still Suing the Federal Government?" Great question.
Why are they? Good question.
Well, the headline answers also has an answer. And what the reporter says is because now it can win. So it's a really great article, and I just want to put it on people's radars because we talk a lot about the antagonistic lawsuits, right? New York and California and Washington State and Hawaii are suing the Trump administration, and they're reversing the fact that Texas and Kentucky and things like that were suing the Obama administration. But this has some really good empirical numbers to show that Texas has actually kept on suing, but what they're trying to do is kind of get a friendly party across the V from them, the Trump administration, which often sees eye to eye with Texas, to get rid of some of these Obama-era regulations that I guess the Trump administration hasn't yet gotten around to repealing on its own. So presents like just a good overview of just how much stuff there is going on in the federal government, and also presents some really interesting questions of like how much are administrations supposed to defend lawsuits that if they kind of agree on policy or don't agree on policy, and who has standing to defend these regulations that are sitting there passed by the Obama administration that maybe Texas doesn't like and maybe Trump doesn't like, but they're the only two parties on the other side of the V from one another. So just a super interesting read. I'll link to it, and maybe we'll talk about these kind of semi-collusive lawsuits at another time. Maybe we'll find some that are less. The one we're talking about, this Kentucky against the Center for Medicaid Services, that's going to be quite antagonistic. These Texas versus Trump are going to be much, much less so. So maybe we can talk about the issues that those suits present at a later
time. And we should be clear, this isn't Kentucky suing the center. This is a bunch of individuals who currently receive
I'm sorry.
Medicaid.
Kentucky is on the same side as the federal government in this one, of course. Exactly. They're going to be friendly. So that's kind of the equivalent here, right? That illustrates it. What if Kentucky were suing the Center for Medicaid Services about some part of Medicaid that it didn't like? You know, how opposed to that lawsuit would the Trump administration be? Interesting question.
I have a Trump nugget that has 3 very short parts, and it's on the theme of the Trump administration's vindictiveness toward poor people, which to my mind is the theme of this episode. Although maybe it's actually about the kind of considered empirical judgment of Seema Verma. Okay, so update number 1. Reuters kind of caught this and did the report on it, and we'll link to the article. But the Department of Homeland Security has drafted rules that have not yet become public, but that Reuters has seen, that would allow immigration officers to scrutinize potential immigrants' use of certain public benefits. So right now, when you get a visa or you apply for a legal permanent resident status, a lot of the mechanisms to do that require you to prove that you will not be a, quote, public charge. That is, you won't be a burden on the government. And historically, that's meant you won't be dependent for cash assistance on the government. That's what the regulations have always said. The Trump administration now wants to include in that calculus things like whether you are sending your child to a government-funded preschool program. So if your kid's in Head Start, you are a public charge for purposes of the Trump administration. Again, incredibly vindictive against people who are making it, right? They're not relying on the government for cash assistance, but who are trying to take advantage of government-sponsored programs the government is sponsoring because they recognize that it benefits all citizens to have, more kids in preschool. Will get penalized for that by an inability to get the immigration status they're seeking. Development number 2 has gotten a little bit more press. Politico, we'll link to a Politico article covering it, but there's been a lot of news coverage. Would replace the current draft budget the Trump administration has produced, would replace half of SNAP benefits, which is colloquially known as food stamps, with a, quote, blue apron style box of food. So rather than getting food stamps and being able to go to your local grocery store or a local market of some sort and decide what you're going to spend those food stamps on, the Trump administration will send you a box of what they think you should eat, which is a boondoggle for all sorts of reasons, right? I mean, A, poor people have nut allergies too. How will they account for that? B, it's so mean-spirited to say that because you are poor and are dependent on the government in some way, we're not only going to restrict your freedom about how you spend your money in all sorts of ways, right? We give you food stamps that you can only spend on food, even if you decided that actually you'd rather spend that money on something else. But we're going to say you don't even get a choice about what kind of food you eat. You have to eat what we send you in this box. So that's vindictive thing number 2. Number 3 is not exactly a Trump administration vindictive measure, but I want to commend folks to the podcast The Uncertain Hour, which I've mentioned perhaps on the show before. Season 1 is a deep dive into the history of welfare. And one of the things that season 1 spends a bunch of time on is basically why welfare is so racist. And one of the conclusions it reaches in consultation with a number of experts at Johns Hopkins is basically the more you put in administrative hurdles and the more you give some caseworker somewhere discretion to deny people's applications on the basis of something, the more it looks like there's a really disparate impact based on race. That is, as you increase the number of hurdles to comply, as you sort of do things like, the Kentucky measure, which says you got to do work or work adjacent things unless there's good cause, and you got to prove it in these 13 different ways, you see this differential as caseworkers you basically can't stay in the program without substantial assistance from a caseworker or a social worker who's invested in helping you kind of fill out this morass of paperwork. And the folks who they tend to think deserve that help tend to be white families, not Black families. So commend you to look at all those things, commend you to think about how in the middle of its war on Muslims and its war on immigrants and its war on Mexican Americans and its war on, just about every other women, just about every other demographic group you can think about, the Trump administration's kind of sustained war on the poorest among us is really changing the way that our society and our governmental infrastructure function.
Yeah, I hadn't heard about a lot of those, and sucks. I mean, it's wrong. It's wrong. It's wrong. It's just wrong. You got to say when stuff is wrong. Anyway, all right. What's right, though, is listening to this podcast. And thank you for sticking with us through the weeds of Medicaid law, dear listeners. We shall be back next week. Hope you enjoyed it at Versus Trump Pod, Versus Trump Podcast at gmail.com, takecareblog.com/podcast. See you next time. The red light of the train shines back on me.